read for us section 217. Is that A, for the confessions allegedly taken by Colonel Mboto and Rapudi.
Rapadu.
Rapadu. That's Rapadu, eh?
Yes.
And Mrs. Cronje.
Coronje, yes.
And then also read the 219.
219A,
out.
yes.
219. 218, sorry. 218, so that you refresh our knowledge.
Okay. My Lord, section 217 reads as follows. Must I read the whole of section 217?
Yeah, so that
Yes.
we all know what we're dealing about.
The heading is admissibility of confession by accused. Subsection 2171. Evidence of any confession made by any person in relation to the commission of any offense shall, if such confession is proved to have been freely and voluntarily made by such person in his sound and sober senses and without having been unduly influenced thereto, be admissible in evidence against such person at criminal proceedings relating to such offense, provided, Roman figure A, that a confession made to a peace officer other than a magistrate or justice, or in the case of a peace officer referred to in section 334, a confession made to such peace officer which relates to an offense, with reference to which such peace officer is authorized to exercise any power conferred upon him under that section, shall not be admissible in evidence unless confirmed and reduced to writing in the presence of a magistrate or justice. And subparagraph B, that where the confession is made to a magistrate and reduced to writing by him, or is confirmed and reduced to writing in the presence of a magistrate, the confession shall, upon the mere production thereof at the proceedings in question, Roman figure 1, be admissible in the evidence against such person if it appears from the document in which the confession is contained that the confession was made by a person whose name corresponds to that of such a person, and in the case of a confession made to a magistrate or confirmed in the presence of a magistrate through an interpreter, if a certificate by the interpreter appears on such document to the effect that he or she interpreted truly and correctly and to the best of his ability with regard to the contents of the confession, and any question put to such person by the magistrate, and Roman figure 2, be presumed, unless the contrary is proved, to have been freely and voluntarily made by such person in his sound and sober senses and without having been unduly influenced thereto, if it appears from the document in which the confession is contained that the confession was made freely and voluntarily by such person in his sound and sober senses and without having been unduly influenced thereto. Subsection 2, the prosecution may lead evidence in rebuttal of evidence adduced by an accused, in rebuttal of the presumption under proviso B to subsection 1. Subsection 3, any confession which is under subsection 1 inadmissible in evidence against the person who made it shall become admissible against him if Roman figure, subsection A, if he adduces in the relevant proceedings any evidence, either directly or in cross-examining any witness or any oral or written statement made by him, either as part or in connection with such confession, and subparagraph B, if such evidence is, in the opinion of the judge or the judicial officer presiding at such proceedings, favorable to such person. These are the provisions of Section 217
Yes.
of Act 51 of 1977.
Right.
I will then proceed to read the provisions of Section 219A, admissibility of admission by accused. 219A, subsection 1. Evidence of any admission made extrajudicially by any person in relation to the commission of an offense shall, if such admission does not constitute a confession of that offense and is proved to have been voluntarily made by that person, be admissible in evidence against him at criminal proceedings relating to that offense, provided that where the admission is made to a magistrate and reduced to writing by him, or is confirmed and reduced to writing in the presence of a magistrate, the admission shall, upon the mere production at the proceedings in question of the document in which the admission is contained, subparagraph A, be admissible in evidence against such person if it appears from such document that admission was made by a person whose name corresponds to that of such a person, and in the case of an admission made to a magistrate or confirmed in the presence of a magistrate through an interpreter, if a certificate by the interpreter appears on such document to the effect that he interpreted truly and correctly and to the best of his ability with regard to the contents of the admission and questions put to such person by the magistrate, and subparagraph B, be presumed unless the contrary is proved to have been voluntarily made by such person if it appears from the document in which the admission is contained that the admission was made voluntarily by such person. And subsection 2, the prosecution may lead evidence in rebuttal of evidence adduced by an accused in rebuttal of the presumption under subsection 1. My Lord, maybe for the sake of completeness, I will also read section 218,
Yep.
should it become necessary. And the heading reads as follows: admissibility of facts discovered by means of inadmissible confession. Evidence may be admitted at criminal proceedings of any fact otherwise in evidence, notwithstanding that the witness who gives evidence of such fact discovered such fact or obtained knowledge of such facts only in consequence of information given by an accused appearing at such proceedings in any confession or statement which by law is not admissible in evidence against such accused at such proceedings, and notwithstanding that the fact that notwithstanding that the fact was discovered or came to the knowledge of such witness against the wish or will of such accused. Subsection 2, evidence may be admitted at criminal proceedings that anything was pointed out by an accused appearing at such proceedings, or that any fact or thing was discovered in consequence of information given by such accused, notwithstanding that such pointing out or information forms part of confession or statement which by law is not admissible in evidence against such accused at such proceedings. These are the relevant three sections
Okay, thanks.
that are in issue.
You'll interpret after whatever I've said. Right, the other day when we postponed the proceedings, I indicated, just to recapitulate the synopsis of what I said. I quoted the case of S versus Soteti and others, 2002, 3 SACR 648. And just to refresh ourselves, in that case, this is what was said. A ruling on admissibility is CR versus Musikwa and others, 1965, 3 SA 529 SRA. Further, the Leonard MacDonald AJP said at 5:30 to 5:31, it is important to bear in mind that a ruling on admissibility is not final. Relevant evidence led in the main trial may be taken into account by the judge or magistrate when reviewing his decision on admissibility, no matter what the source of such relevant evidence might be. There is no reason why this should not also be the position when a trial within a trial is held. The Leonard Shoes, Judge Shoes, in the case of S versus Muchinindu, 2002 SACR 313, Witwatersrand. A ruling on admissibility on a trial within a trial is interlocutory and may be reviewed at the end of the trial in the light of later evidence. The principle in itself shows that subsequent evidence in the main trial may decisively affect the determination of the issues in the trial within a trial. And if subsequent evidence may, why not also earlier evidence? Right, with that caveat, let me add the case of S versus Ntuli, 1993 to SACR 599, Witwatersrand. It's a judgment on appeal which was before Zulman and Nugent, who in my view are some of the most brilliant judges this country has produced. Now, having the caveat of what Soteti says, I'm going to read in full what these judges say. Accordingly, the only reason advanced in the judgment for admitting the confession was that the evidence given by the appellant was unsatisfactory. The evidence which he relied upon, that is the magistrate, for reaching this conclusion was all given after the confession was admitted and it related to the contents of the confession rather than the alleged coercion. The evidence relating to the coercion had been given during the trial within a trial and was not scrutinized at all. It is difficult to see in those circumstances on what grounds the magistrate admitted the confession in the first place. The magistrate appears to have been under the impression that a confession may be admitted during a trial, provided only that at the end of the trial, the evidence as a whole is sufficient to justify the admissibility. The admission of a confession on the basis that evidence may later emerge to justify its admission would, in my view, constitute a gross irregularity and reduce the procedure for determining whether a confession is admissible to nothing more than a charade. The admissibility or otherwise of a confession falls to be determined on the evidence placed before a court in a trial, within a trial, together with the admissible evidence which has gone before it. If at the end of the trial, within the trial, the requisites for admissibility have not been proved, the confession may or must be excluded. It cannot be admitted on the basis that other evidence may emerge during the course of the trial to justify its admission. Once a confession is admitted, its admission is provisional only in the sense that evidence may thereafter emerge which requires it to be excluded. Then it goes the case of R. Malozani, 1952, 3 SA 639, that's 644E. It's an AD case. The other case is S versus W, 1963, 3 SA 516, Appellate Division. And the other case is S versus Zameni, and another 1971, 1 SA 807. Right, that is the law. So it mustn't be argued that this judge didn't consider the evidence regarding coercion. In other words, the synopsis of the encapsulation of the evidence, the salient features are this, that when the state intended to bring into play by introducing the so-called alleged confessions or statements of accused number 1 and 2, and the pointing out by accused number 2, the defense objected. And the principal objection was that, 1, they did not make statements. They did not make confessions. They were told to sign documents which were fully completed, and they were told sign here, sign there, initial here, initial there. That was the initial defense. The second defense is that they were assaulted, tortured, severely, as Mr. Mgomezulu put it, severely tortured, tubed, electrocuted, kicked, in order to elicit their signatures on the documents. In other words, these accused before court, their evidence is they don't know the contents of the confessions. They don't know. They were never read to them. And if you go further, accused number 1, for instance, says when he went to sign the confession or statements before Maboto, I think, Maboto never even sat down. When Maboto came, they were assaulting him. All that group of policemen. And Maboto then called him aside and said, hey, you know what? Why don't you sign this document? These guys are going to injure you. And then, to save his life, accused number 1 says he signed. No discussion with Maboto in an office sitting down, according to accused number 1. Accused number 2 also says when he went to sign the alleged confession or statement before Mrs. Kronje, all he said when he got in, even before Mrs. Kronje could introduce herself as a magistrate, he came in and told Mrs. Matlaping, the interpreter, that, may you tell the lady, please, that 6 weeks I haven't had a bath, from the 16th of June, I think. And also that I want to speak to my daughter, I want to speak to my partner or parents. And that was it. And he sat down and looked at the ground. And Mrs. Kronje, what he did was, he was busy with his computer. She never asked him anything. All she was interested in was the computer, and then she would get out and gossip with a fellow magistrate or fellow white lady and come back. Mokgono was going in and out, consulting with Mrs. Kronje. Nothing was discussed between accused number 2 and Mrs. Cronje, except, as I said, that I haven't had a bath and I want to speak to my daughter and my partner. Nothing. The same applies for Rapudu. Accused number 2 says, no discussion with Rapudu, nothing. He was just beaten up and told to sign. So in the main, that is the salient aspects of the evidence relating to the trial within a trial. It's obvious that Keninda, Maholewa, and others gave evidence. But what I want us to understand is that this court, after careful analysis of the evidence adduced by the state, and after careful analysis of the cross-examination interposed by the defense against the evidence adduced by the state, and after careful analysis of the rebuttal evidence of accused number 1 and 2, and the cross-examination interposed by the state, and after careful analysis of the heads of argument by all the parties concerned, and the verbal submissions made by all the counsels in this court, I have dealt, not like this magistrate did, I've dealt with all the evidence relating to whether the said alleged confessions were made freely and voluntarily in the sound and sober senses of the deponents without any force or coercion. I've dealt with all that, and I've also dealt with the other primary defense by the accused, that all the accused were not apprised of their constitutional rights, meaning section 35(5) of their rights. They were never apprised according to that. And this court even also interrogated that. And as we all know, section 35 encapsulates the concept that if any evidence is acquired through the infringement of the Bill of Rights, that evidence should not be admitted into the record of the proceedings relating to section 1(7) and section 1(8), even section 1(9) of the Criminal Procedure Act. Right. Consequently, after going through all that evidence carefully, this court has reached the following conclusion. 1, it rules that the confession made by accused number 1 was made freely and voluntarily without any coercion when accused number 1 was in his firm, sound, and sober senses. 2, the confession made by accused number 2 in respect of the said confession being taken by Mrs. Cronje, the magistrate, the court rules that it was made freely and voluntarily without any coercion when accused number 2 was in his full and sober senses. And also the confession made before Colonel Rapudi was also made by accused number 1, 2. Freely and voluntarily without any coercion when he was in his sound and sober senses. And also the pointing outs made by accused number 2 before Colonel Khadebe were also made freely and voluntarily without any coercion when accused number 2 was in his full and sober senses. Okay, that is the ruling. Yes, Mr.
My lord, may we perhaps adjourn for a short while just to have a plenary meeting with my colleagues as to the conduct of the proceedings going forward.
Okay, fine.
We discussed that briefly just before we resume this morning.
So how long do we adjourn?
I think about 15 minutes should do.
Okay, 15 minutes.
Statements of both accused number 1 and 2 in
you interpret after he's spoken, then we would have adjourned.
Correct.
Maybe, my lord, while we're waiting for,
Yeah.
for the gentleman to come up here, at the commencement of the proceeding, I don't know, requested the state to really to record the relevance of the provision, the relevant provisions of the criminal procedure.
I did.
Thank you, ma'am. And then the state said those, the provisions that you read were the only relevant one. So I think
No.
it's section 219.
Yeah.
Yes.
I said 219. I remember Mr. Ramosipidi said 218. You remember?
The court referred to 219A,
Yeah.
capital A, that is admissions.
He read it. Did you read it, sir?
He read 219A.
Yes, I read section 219A.
He didn't read the pointing out section.
Yes, 219A.
Is that the pointing out section?
Yes, indeed, you know.
Now, what is it?
I'm referring to 219, where it says the confession made by one person not applicable to the other
Yeah,
one.
yeah.
Yes, that should also be encapsulated into the record.
You read that too, ne?
No, it
No,
didn't.
no, not 219. my lord.
Yeah, you can read it.
Thank you, my lord.
I remember you reading about admissions. Yeah, just read the addendum there.
It's 219, it's actually a section, not really an addendum. It's a standalone section. Yes.
Well, it's an addendum
It's
section.
It's a standalone provision. my lord.
Okay, thanks for that. Do you know what is a postia?
Yes, I do, man.
Why don't you use that word? Okay.
I'm having it in mind that the coaches are well aware that posture is applicable here.
Yeah, you should have said. We have to-
Postia, man.
Yeah,
As it is the court.
we must be lawyers, must speak legalese, as Mr. Ramosipidi says.
That's appreciated.
The sections that were put on record were about admissibility.
Admissibility, yeah.
Yes. There's now a request to also read section 219 with the heading confession not admissible against another. Section 219, no confession made by any person shall be admissible as evidence against another person.
That's it.
Yes.
Okay. Yes, can you interpret then for the gentleman?
Thank you, my lord. Bobaba, ngaphambi kokuthi siqale namuhla inkantolo ithe umnumzana uBaloyi afunde imithetho ehambiselana nokugonyuluka. La ukuthi uye wafunda ke ukuthi ukugonyuluka kwamele kwenzakale ngendlela eyiphi ukuze kwamukelwe la enkantolo. Ushilo ukuthi kwamele umuntu kube uyena ofisayo ukutshela amaphoyisa lokho noma labantu labagonyuluka kubo, futhi kwamele lo muntu loyo agonyuluke kumuntu ozimele ongahlangani nokuphenywa kwecala obizwa phecelezi i-justice of the peace noma umantshi. Lo mantshi naye angahlangani necala. La ukuthi kwamele lo muntu loyo anikwe wonke amalungelo wakhe bese ke yena angakwazi ukuthi agonyuluke ngemva kokuthi sekacebiswe ngawo wonke amalungelo wakhe. Ufundile namanje usanda kufunda omunye umthetho oshoyo ukuthi ukugonyuluka okwenzwe yimina akusebenzi nanokho ngingasho ngithi uThembi wayekade ekhona umzekelo. Ukugonyuluka kwami ngeke kusebenze kuchaphazeleke komunye umuntu wesibili. Njengoba ikuthi inkantolo manje njengoba ngisazonifundela ukuthi ukugonyuluka okwenzwe usibiya akusetshenziswa ukuchaphazeleka kuntanzi. Ukugonyuluka kwantanzi uma engabe ekhulume izinto ngosibiya ngeke lokho kusetshenziswe kuye usibiya. Manje ke inkantolo ke ifundile nayo imithetho eyikuthi imbalwa eyifundile. Ngizoqaphuna nje kancane kuthiwa laphayana ukugonyuluka kwamele kubonise umuntu ukuthi lo muntu loyo wayekade naye etsheliwe amalungelo wakhe. Lokho kugonyuluka lokho kwamele kuboniswe ukuya ngomthetho ukuthi kona kuyavunyeleka, futhi inkantolo kwamele izenakalise yona ukuthi lo muntu wayekade engaphoqwanga ngalesikhathi egonyuluka futhi lo muntu loyo wayekade ekhululekile ngalesikhathi egonyuluka. Istatement leso siyenziwe umuntu angaphoqwanga futhi lo muntu loyo angashawanga ngalendlela eyikuthi umthetho usho ngayo. Futhi ke kuyabonakala ukuthi ebufakazini ebuzile kuthiwa umnumzana uSibiya nomnumzana Ntanzi bona bathe abazi lutho into ebekade ibhalwe laphayana, bona bashayiwe baphoqwa ukuthi basayine la ukuthi uKennel Mbotho uma efika kumsolo wokuqala umnumzana uSibiya ufike nje wathi kuye ndoda sayina la noma labantu laba bazoqhubeka bakushaye ngoba ukuya ngomnumzana uSibiya uthi uKennel Mbotho ungene elibele eshawa la ukuthi wamisa ke ukuthi animiyeke bese ukhuluma naye ukuthi sayina ndoda noma labantu bazoqhubeka bakushaye. Uthi umnumzana uSibiya yena akazi lutho ukuthi kade kubhalweni, akafundelwanga, akafundanga naye, akashongo lutho izinto ezibhalwe laphayana. Manje ke umnumzana Ntanzi naye ushilo ukuthi ke naye laphayana akashongo lutho into ayenzile uma efika laphayana kumantshi ufike wahlala phansi watshela uTolika ukuthi sisi ngicela utshele umama lo womuntu omhlophe ukuthi mina senginesikhathi ngingagezi futhi ngingathanda ukuthi ngikhulume nomndeni wami, ngikhulume nezingane zami, ngibatshele nokuthi ngikuphi njengoba ikuthi mina abazi ukuthi ngiboshiwe. Manje ke umantshi yena wayekade elibele eqhubeka kwi-computer yakhe elibele ephuma futhi umhola naye bekalibele eza ezokhuluma nomantshi loyo ukuya ngomnumzana uNtanzi. Ngemva kwalokho uye watshelwa ukuthi asayine into eyena angazange ayitshele umuntu, akazange ayitshele umantshi nalo yaToliki uthe ukhulume naye nje ngalokho mayiqeda yena umnumzana uNtanzi wabheka phansi akazange akhulume lutho. Bese ke futhi umnumzana uNtanzi ushilo ukuthi nakumnumzana uRaphadu yena akazange asho lutho, yena watshelwa nje ukuthi asayine ngemva kokuthi sekashayiwe. Manje inkantolo isahlulelo eyisithathayo akusisona isinqumo, isahlule akusiyona ijudgment phecelezi iruling. Manje ke isahlulelo senkantolo sithi sona ngemva kokuthi sibone silalele ubufakazi bonke bawonke umuntu, abofakazi abazile enkantolo ababizwe umshushisi futhi nabasolwa nabo uma beza bezophana ngobufakazi babo nofakazi obekade ezile ebizwe abasolwa. Inkantolo ngemva kokuthi ilalele wonke lobo bufakazi yona ithathe nasi isahlulelo. Into yokuqala ukuthi umsolwa wokuqala umnumzana uSibiya yena ugonyuluke ngendlela ebekade isemthethweni, wayekade engaphoqwanga futhi akabonisanga nokuthi wayekade eshayiwe njengoba esho. Manje inkantolo ithi ukugonyuluka kwakhe iyakwamukela. Isahlulelo sesibini kumnumzana uNtanzi ithi nakhona kuyabonakalisa ukuthi ugonyuluke yena ebekade engaphoqwanga, yena wayekade efuna ukugonyuluka phambi kwamantshi uKronye futhi wayekade enoToliki. Futhi nakumnumzana uKennel Raphadu umnumzana uNtanzi uye wagonyuluka nakhona ebekade ezimisele engaphoqwanga, engashawanga, engazange futhi athuselwe ukuthi agonyuluke. Manje inkantolo iyakwamukela lokho kugonyuluka kwakhe umnumzana uNtanzi kokubini okukamantshi uKronye futhi nalokho kugonyuluka kuKennel Raphadu. Nokuyokhomba obekade umnumzana Sibiya ehamba nomnumzana noKennel Hadebe nakho kuthiwa kuyavunywa ukuthi lokho kukhomba kusetshenziswe kubonakaliswe ukuthi kwakade kusemthethweni. Umnumzana uSibiya yena akaphoqwanga futhi akazange athuselwe ukuthi aye lapho ayokhomba. Ningakhohlwa umshushisi ufundile ukuthi ukugonyuluka nokuyokhomba uma igama lomuntu omunye ebekade kukhulunywe ngaye ngeke lokho kusetshenziswe ngakuye lo muntu loyo. Nizwile bafethu, niyazwisisa? I have asked the accused, my lord, if they understand,
Yes.
and they nodding their head to show that they do understand, and I have interpreted
Sorry.
the ruling of the court.
Did I say the pointing out was done by accused number 2 also?
Number one.
Number 1?
Yes, my lord.
Okay, fine. Yes, Mr. Moloi.
As a court, please, my lord, after consultation with my colleagues, we have agreed, subject to approval by the court, that we can adjourn the matter to tomorrow for the continuation of the proceedings, naturally going back to the main trial, and we will then continue with the evidence of the witnesses who testified in the trial within the trial.
Is that the procedure?
They will now be testifying in the main trial.
Hello, is that the procedure after a ruling?
Well, our understanding of the procedure is that the witnesses must now come back in the main trial to put the contents
Oh, yeah.
of the confessions on record.
Now you are talking. Yeah, I don't have any problem. You can adjourn until tomorrow then. 10 o'clock, is it?
Ukuthi icala lihleliselwe kusasa ukuze labofakazi labo bekade bephana ngobufakazi mayelana nokugonyuluka beze kusasa kuzoqhutshekwa manje ke kungenwa kuyo indaba leyana yokugonyuluka bese icala liyaqhubeka kuyiwa kulesi sigaba esibizwa i-trial kuzophanwa ngobufakazi kusukela kusasa ukuqhubeka.
Yes, Mr. Masipidi.
My lord, at this point, we are going to request that accused number 1 and 2 not be immediately taken to prison so that we can, all of the accused persons that they not be immediately taken to prison so that we can consult with them, especially containing to the contents or the annexures to the performance.
Okay, where are the chief wardens? Who are the persons responsible for transporting the accused? Are you agreeable to that suggestion, sir? Yes, Lord. You are demoting me now. Just continue, Jen.